Mr. Mathias Emeribe joins us now to shed some light on this matter. He's a legal practitioner. Thank you for coming on this morning.
Thank you.
Well, this matter has been on for a while, but this fresh perspective about commissioners forming a quorum before any valid decision can be taken. From what you've been following on this same matter, what's your impression?
Well, I want to start by saying that naturally, once the law makes provision as to how things should be done, the proper thing that should be done in such a situation is for the authorities concerned, who are in fact the people vested with the power to execute that law, to carry it out to the latter. Now, the Constitution made provision for 12 national electoral commissioners. Now, if you put that as against the chairman who made it 13, it is required...
Is it 12 plus herself? That's 13.
12 plus the chairman, making it 13,
okay, so
to speak. Now, what it means, therefore, is that if you must form a quorum, by virtue of Section 157, you need 4 plus, so to speak, because you need 1/3 of that number for you to form a quorum.
1/3 of whichever
1/3 of the number of that 13.
All right.
Of that 13. Now, the implication, therefore, is that if you are unable to reach or to make up that number, whatever decision that you pass is of no moment. That's what it simply will mean. Now, if an election is coming up, for instance, the Bayelsa and Kogi election, the question that will be asked is that, who are those who will form the quorum to take decisions as to that particular election? That's number one. Now, the question as to the leadership of INEC is also very fundamental here. Because first, the question that will be asked is that the woman, with all due respect, the current acting chairman, in quotes, was she legally appointed to be in that position? It's a fundamental question. And that question requires a legal answer for anything proper to be done in respect of same. And what do I mean here? Now, I listened to the last the clip that you showed, when the answer she gave was that, look, Shoebi was appointed as acting chairman in 2010 by Jonathan. But I beg to disagree with the position as canvassed, using it in supporting her appointment. You know why? Because the law under which Shoebi, if assuming but not considering that that was the position, the law under which Shoebi was appointed is different from the law that we're operating today. And what do I mean here?
Yeah.
What do I mean here? Now, if you go to the provision of the 1999 Constitution as amended, the first alteration was done was signed in 2011. It was signed into law in 2011, though to take effect in July 2010. Now, the INEC chairman, the former INEC chairman, was appointed in June 2010, so to say. Now, what it means, therefore, is that the law under which they operated then was the law, the natural law as the 1999 Constitution had it then. What do I mean here? Under the 1999 Constitution, the power to appoint vests purely with the president, in other words, in terms of approving or appointing and then the confirmation. Consequently, he has what we may call an implied power if it does happen that, look, there's a vacuum to appoint an acting chairman. So there was a law that tends to support his position there. But because people have not bothered to look at the alteration, the first alteration that was made under Section 160, because Section 160 in its natural state does not have a proviso, then in its natural state. But after the alteration of 2010, the alteration that was made in 2011, so to say, that was signed into law in 2011, precisely in January 10th, 2011, it follows, therefore, that that natural state, which requires just simply the president, no longer subsists. And that is why that proviso now says that provided, in the case of INEC, the issue of the president to regulate or whatever will not apply. Now, you ask yourself a fundamental question. That question is this: why would the provision of the Constitution make provision for such? I mean, why would the drafter of the Constitution now make or put such? It is not far-fetched. You go back to Section 81 of the Constitution, which deals with financial autonomy, and Section 84 of the same Constitution that deals with financial autonomy of INEC. And then you look at the explanatory note to the alteration of the 1999 Constitution. It says the basis of that particular alteration is to give financial autonomy to INEC and to National Assembly, so that there will be what you call first-line word charge. Are you getting it? Now, putting these things together, when you want to do what you call a community reading, you discover that the whole intent is not unconnected with the fact that for you to stand in there as the chairman of INEC, it must be somebody with what you may call proven record of integrity, one. And number two, it must be somebody that doesn't have any partisan affiliation. And three, it must be somebody that must have been accepted by all. And that is why it is equally instructive to note that by virtue of the Constitution, it is not only the national, talking about the Senate that confirms, the Council of State has a role to play in advising. And the Council of State is made up of the following: the President, the Vice President, the Senate, the Senate President, the Speaker, the former Chief Justices of the Federation, so to speak. Then you equally have the heads of service, and the former and the governors, all the governors. Now, what is that supposed to mean? It means that there will be input from all to be sure that anybody that you are throwing up will be somebody that will be acceptable to what, to all. Therefore,
input in the form of advice.
Yes.
Are they bound to accept that advice?
By implication, the Constitution has provided that these are people that you must consult. Whether you are accepting them or not is a different ballgame. The question is that the chairperson or the person that is now acting as the chairman of INEC, was there any input by this body in question before she was appointed? Right. The answer is, of course, no. The person that the former chairman also handed over to, was there any input from those people before he handed over to? Now, let me tell you, the issue of the former chairman, by virtue of the Constitution, is not in dispute from my own point of view. And why do I say so? Because the provision says that, look, under the proviso says that if you read, perhaps I think I will do better by reading section 160 first, and then we'll go to the proviso, and you see what the proviso says. Now, if you look at section 160 of the 1999 Constitution, it is to the effect, it is thus, sorry for, it says, this is the provision, it said this: subject to subsection 2 of this section, any of the bodies may, with the approval of the President, by rules or otherwise, regulate his own procedure or confer powers and impose duties on any officer or authority for the purpose of discharging its functions. I repeat, for the purposes of discharging its function. I think the operative word here is discharging of what? Function. Now, what it means, therefore, is that we are dealing with INEC that must carry out its statutory, in fact, its constitutional role of discharging its function, which is organizing election and so on and so forth. Now, does it include handing over or appointing a substantive chair? Now, let me tell you, it's an administrative action for the purposes of INEC functioning, pending when the appointing authority, which is the President, appoints a substantive, because there is no room, I repeat, there is no room for acting chairman of INEC. It is unknown to the Constitution. So if the President is to appoint, yeah, what is the contradiction of you saying they've not stuck to section 160? No, the contradiction here is that the fact that he gave him power to appoint, so to speak, does not by extension give him the power impliedly to appoint an acting chairman. It only gave him power to appoint a substantive chairman of INEC. And that can only happen when the due process as provided under the Constitution has been met, which is, like I said, the advice from the National Council of State and the confirmation by the Senate. In the absence of this, it is practically impossible. I repeat, it is practically impossible for the president to embark on the appointment of the INEC, acting INEC chair, without the consultation, without going through this process. It will be ultra-vires the president, it will be unconstitutional, it is null and void.
Let's pull back a little bit and look at the other commissioners in INEC.
Yeah.
2 of them are likely to be leaving in the next 2 weeks. What does it portend for the commission?
It still goes back to the point I was making. That first, if the substantive, the quote and unquote, the chairman of, the acting chairman, constitutionally is not recognized. And it happens that the other 2 will be leaving in the next couple of weeks, so to say, or days as the case may be. Then it means that we are in a state more like we are in a quagmire. We're in a quagmire in the sense that the appointing authority have shirked their responsibilities in doing the needful.
How is it a quagmire? Because if 2 leaves, you have how many? You have 2 more, plus.
And I said it here, for there to be a quorum under section 157 of this very constitution, it must be 1/3 of the total number that constitutes the commission.
Not the total number that exists.
No, the
in the
total number that
whatever point.
No, the total number that constitutes the commission.
So, but hold on. Are you now saying that if this 4 plus the acting chair that are there now meet, they've not made up a quorum? Is that what you're saying?
First of all, there is what we may call legal impairment of the acting chair, because first she is no longer a member. Her term or tenure expires since 21st day of July, because it's for a 5-year term, and it's a constitutional term inclined. Because first the constitution is clear, and the Supreme Court has variously interpreted that provision on the issue of time. Once time has been given, it stands like a rock of what? Gibraltar. You cannot shake it. So that 5-year term, except renewed, and if it must be renewed, it must go and follow the format, the due process.
So now that the commission is preparing for the next elections, Kogi and Bayelsa, what does this mean?
The implication, therefore, that any election organized by the commission as it stands is of no moment. It's a simple thing for any losing party to go before the court, and they will nullify that election. Because it's like a court sitting without the proper panel. If, for instance, a constitutional matter comes up that requires 7 justices of the Supreme Court to sit, and it happens that there are 5, the quorum has not been formed. The panel has not been formed to give what we may call a valid decision. In the same vein, if you go to court of appeal that requires 3, and it's only 2, it has not been formed. That is a basis to say that the court has no jurisdiction to hear the matter. So as it stands, INEC has no jurisdiction to conduct any election. They have no jurisdiction to conduct any election as it stands presently.